in this video we'll start from the previous lecture. So in the last lecture we discussed that what is in polity in general and what is the organization of Indian polity. So from there we also discussed that the source of power and the source of this political organization is the constitution, right? So in this we'll discuss what is constitution. So constitution was framed by the Constituent Assembly, which was framed during the independence of India, and they made the constitution in such a manner that it is still relevant in today's society. So constitution is the most basic, the most fundamental and the supreme law of land. What does these three terms imply when we are talking about the basic law of land? That means that the constitution does not include all the laws which were required to run the Indian polity. No, it only includes the most necessary and the most basic laws which were required. And some of the laws were left for the parliament to make when it is required as per the time, right? That's why we are saying it's the most basic law of land. And then we are referring to it as a fundamental law of land. What does the term fundamental implies? See, fundamental means that any law which has to come in Indian society, it has to come through constitution, right? So that means that inherently also means that any law which will be there in force in India will also come through this particular constitution and cannot go against the constitution itself, right? So it has to abide, it has to be within the walls of the Constitution of India. That's what makes the constitution supreme law of land, right? So when we are referring to it as basic, fundamental and supreme law of land, then that means there are other laws also. So what does the term law of land implies? Law of land implies all the laws which are enforced in India. All the collection of these laws is called law of land, and constitution is the most supreme, right? It's the most fundamental, it's the basic, it's the most supreme. No other law can go against the Constitution of India. So in order of priority, let us understand what are the various laws that can be enforced or that are enforced in Indian society. So we discussed about constitution, it came through Constituent Assembly. Now we have statutory laws. Statutory laws are the laws which are framed by parliament or state legislative assemblies, right? Parliament or state legislature. Say for example, your right to education, your right to information, all these are statutory laws, and they are the laws which are required from time and again whenever the time, every if we see in the sessions, like continuous, we have 3 sessions in a year, and in each session parliament passes few laws. So all those laws are called statutory laws. And then you have ordinances. What are ordinances? Ordinances are temporary laws. Temporary laws. Why temporary? Because maximum they can be there for a period of 6 months, because it is made by president and governor, right? In the absence of parliament and state legislative body, whenever these two bodies are not in session and there is a urgent need of any law, then on the aid and advice of the Council of Ministers, the President or the Governor come up with the ordinances which can stay maximum for a period of 6 months. So these are temporary laws, but they have the equivalent enforcement as of statutory laws, right? Then come your bylaws. So Parliament and state legislative bodies are your major law-making bodies, but then there are also small law-making bodies which are panchayat, just municipalities. The laws made by these bodies And why I am saying that they are the lesser law making bodies, because it is the state legislative body which is delegating them the power to make laws as per the provisions of constitution that we'll discuss later. So that is why panchayat, the laws made by panchayat and municipalities are known as bylaws. So they have less enforcement power as compared to the statutory inferior status, not enforcement power, but they have inferior status as compared to the statutory laws. And then you have rules and regulations. See, all these are laws which are framed, but when it comes to rules and regulation, they are given by executive bodies. Say for example, your model code of conduct, it is by election commission. So these documents are known as rules and regulation. So in the order of priority, we have constitution, then we have statutory laws, then we have ordinances, bylaws, and rules and regulation. This is what law of land consists of. Right? Now let us discuss the type of constitutions. See, broadly, if we divide the constitution, we can do the division on three bases. One is your unitary or federal, whether the constitution is unitary or it is federal. So what does the term unitary implies? See, unitary implies that the entire power is in the hands of center. There is one single center of power, right? And there is no hierarchy between the powerful bodies. No, it's just one single center of power. That is unitary constitution. And when you talk about federal, there is a hierarchy and there is a separation of power between the center and its federal units, be it states or anything else. But there is a division of power and there is a hierarchy, right? So that is federal and that is unitary. So if you see UK, it is a unitary constitution. And when you see federal, US is federal to the extent that even the states of UK, the subunits of US, can also opt to secede from the union. They can opt not to be with the union as well. And that is the federation that US is. But when we talk about India, what do you think is the status of India in terms of these two? So India is a quasi-federal. And why we are saying that India is a quasi-federal? Because India is a federal in the sense that there is a division of power between the states and between the center. But at certain times it becomes entirely a unitary constitution. Say for example, during the time of emergencies, it becomes entirely a unitary constitution. Secondly, unlike the USA, as we have seen that the states have the power to secede, but if you read the Article 1 of Constitution, it says that India, that is Bharat, is a union of state. It doesn't mention it's a federation of state. So that means it's a union in which the state do not have the right to secede, which make it more inclined towards the unitary constitution. That's why we say it's a quasi-federal, right? Now coming to the second division, that is democratic and autocratic. See, democratic means the source of power is people, is the civilians of the country. If you read India's preamble, the first line says, "We the people of India." That means the source of power is the people of India, not the parliament. When you say autocratic, that means the source of power is the government. It's not the people. People are not the source of power, right? So if you see, China is an example of autocratic nation. Although they claim themselves to be democratic, but by and large is an autocratic country. Then we have written and unwritten constitution. So, written and unwritten. What does the term written and unwritten implies? See, as we know, we have a constitution in which laws are written, right? Which is the basic fundamental laws, right? Now, whenever the laws are codified in a single document in a structured manner, then that is known as a written constitution. And when you do not have codified laws which are written in a particular document in a single structured manner, then that is non-codified and that is unwritten constitution. Codified means, like, if you see Indian constitution, the first part is Indian territory, right? That means वो establish क्या करता है? If this is the constitution, the first part talk about कि what is it about, है किस territory के बारे में, which territory are we talking about when we are referring to as India. The first part is your territory. The second part is your citizenship. Now we have a territory, then there must be people who need to be governed. The second part talk about who are the people who will be staying in India and who will be called as the citizens of India. Then the third part talks about fundamental right. That means if you have a territory, if you have people living in it, then those people must have some fundamental rights if they are living in that particular country to have a peaceful survival, right? So third part is about the rights of citizens. And this all, by the way, implies that we have a democratic constitution because the priority is given to the citizens, not to the parliament. Then you have responsibilities, DPSPs. These are the rights and these are the provisions for the parliament to fulfill. This is the enabling provisions for the parliament. Then you have directive principle, it says that the parliament has to follow in order to the fifth is your fundamental duties, right? If you have a territory in which citizens are living, they have their fundamental rights, then you have DPSP, and then you have duties of the citizens who are staying. You have some responsibility, the government will be doing a lot for you, and then you also have some responsibility, and then the provisions related to the parliament executive comes into place, right? So this is a structured document, and when you see, this is about India, and when you see in UK has an unwritten constitution. There is no such codification which is given in their constitution, right? So if you see, they have discrete laws which are there, which together run the polity of the country. However, there is no one document. Say for example, they have Magna Carta, right? It is still there, but they do not have some written codified laws. Then you have enacted provisions. In written constitution, what is there? The provisions are enacted. That means there was a special legislative body which framed the constitution, and then the constitution was enacted, and all the provisions of the constitution came at a single time, right? But when you see unwritten, it is evolved over a period of time because nobody was there to write it down at one point of time. So the provisions of the constitutions evolved. It's not that they are running in absurd manner, but they do have written provisions also, but in a haphazard manner, not one document, and it didn't come up overnight. It was evolved over a period of time. That is the difference. And then you have constitutional supremacy. In written constitution, you have constitutional supremacy. Why? Because constitution becomes the source of power. It sets the power and privileges of the government, and it gives the power to and rights to the citizens also. So the constitution is supreme, and as we say that nothing can go against the constitution, so that means we have constitutional supremacy. But coming to the unwritten provision, unwritten constitution, we have parliamentary supremacy. Why we have parliamentary supremacy? Because it is the parliament who is framing the constitution itself. There is no other body to frame, and it is not framing in one day. It's like from time to time they are bringing in laws which are required. So if it is the parliament who is bringing the laws, there is nobody who can override the parliament, right? So we have parliamentary supremacy. And deriving from the same provision, as there is constitutional provision, judiciary supremacy, judiciary is there to ensure that constitution remains supreme, and parliament or other legislative bodies doesn't bring any such laws which are going against the judiciary, against the constitution. So that make it more powerful. But when you talk about unwritten constitution, the power of judiciary is restricted. It is only restricted to executive action. Again, because it's the parliament who is framing the laws, the judiciary cannot go against the legislature. Right? There is no judicial action which is given against the legislature, but only executive. So it is more powerful. The power of judiciary is restricted in unwritten constitution. Then the written constitution can be flexible, can be rigid, and can be both. What does the term flexible implies? The term flexible implies that one body can change or amend the constitution. Right? Say for example, if you see Sri Lanka, Bangladesh, they have a flexible constitution. On the other hand, if you see US, they have rigid constitution that it's very difficult to amend. It needs approval of all the organs like subunits also to amend, right? But in India we have both. In USA, even for day-to-day bills related to day-to-day activities, they need to have permission of the states. But in India, we do not have such. We only need permissions of the state when the matter is concerned with the federation, federal principles. Other than that, for day-to-day activity, it is quite flexible. It's not rigid, right? And we'll discuss the amendment in maybe after 1 or 2 classes. But as of now, you need to understand that written constitution can be flexible, rigid, and both. And India have both, a mix of flexible and rigid constitution. Whereas unwritten is flexible, again because parliament or any other the central legislative body is framing the laws, so it is up to them to change it at any point of time, because there is nobody who is supreme than that, right? And then, as we discussed, in US we have unitary, in UK we have unitary constitution, simply because of parliamentary supremacy. And then you have here, it can be federal, it can be unitary, both can be there. There is no fixation. India have a quasi-federal, right? So this was about the various characteristics of written and unwritten constitution. So we have discussed types of constitution. In the next lecture, we'll be discussing the types of majorities, which is very critical topic and very important. So till then, you read this, and if you have any questions, any doubt, please ask in the comment section below. Thank you and have a nice day.